she owns. Well, if she owns all of the community property assets, her plaintiff can reach all of the community property assets, not just her half, whatever that is. If the husband gets sued, his plaintiff can reach all of the community property assets because that's what the husband owns. So what type of planning do we do for clients who live in a community property state? A little bit different than in the so-called common law states. In the community property states, spouses can enter into what is known as a transmutation agreement. And a transmutation agreement, it's a form of a postnuptial agreement, allows spouses to basically opt out of the community property system. The transmutation agreement, which is actually fairly simple, like a 4-page agreement, will say something like, today we own all of these community property assets. No more. From now on, these assets are the separate property of the husband, and these assets are the separate property of the wife. And as soon as we do that, there is no more community property. And separate property in California, in Oregon, in any other community property state is exactly the same as separate property in any other state. Meaning one spouses have separate property. If tomorrow the wife gets sued, the husband's separate property assets are not reachable by the wife's creditors. Husband gets sued, the wife's assets are protected. And it's done through the so-called transmutation agreement. If the transmutation agreement is done correctly, it is extremely difficult to challenge. So what does it mean, done correctly? The most important thing to know about transmutation agreements is that we have to have an equal split of the assets by value, meaning that husband and wife owned $1 million of community property assets. The transmutation agreement should allocate about $500,000 to the husband and about $500,000 to the wife. The split does not need to be mathematically precise, to the penny, but we want to get it as close as we can to an equal, even split of the assets. That makes it then a transfer for fair market value between the husband and the wife. Makes it very, very difficult for a plaintiff to challenge this as a fraudulent transfer. So let's say that we know that the wife, she drinks a lot, she gets into a lot of car accidents, she is the one who is likely to be sued. So if we're doing this asset protection planning and we're having them enter into a transmutation agreement, knowing that the wife is the one who is a lot more likely to be sued, what are we going to do? Well, one option, kind of the simple option, is to simply take each asset, split it down the middle, right? Husband gets half of the residence, wife gets half of the residence. So if she gets sued, only that half is reachable by creditors. It's possible, but it's not the best way to go. Another way is to just kind of give them, one gets an asset, the other gets an asset, so long as at the end of the day, they wind up at 50-50. You can do that, not the best way to go. What is the best way to go? We want to pick and choose which spouse is going to get which asset. How do we do that? Well, there are assets, as we discussed earlier today, that may not be reachable by claims of creditors. For example, let's say that the spouses live in the state of Nevada. State of Nevada has a $250,000 homestead exemption. And let's say that that's all the equity that the husband and the wife have in their home. Well, if the wife is going to be sued, we can have her keep the house with its $250,000 of equity, allowing us to transfer a different asset to the husband. We're not worried about the house. The house is not reachable by claims of creditors because of the $250,000 homestead exemption. And it will allow us to take another asset that maybe is not exempt from claims of creditors and give it to the husband. Okay? So we pick and choose who is going to get what type of asset. And what we call the high-risk spouse, the one who is likely to get sued, he or she is going to get those assets that are either difficult for a creditor to reach or are simply exempt from claims of creditors. Or maybe we'll give them, if we have those, we will give them assets that are simply undesirable because there's nothing that a plaintiff can do with them. For example, let's say we are representing a medical doctor. That medical practice may have a lot of value to the doctor, may have a lot of value to some other doctor willing to buy the practice. But this creditor who happens to be pursuing our client, the practice has no value to him. Yeah, he can, factor accounts receivable, sell that office chair that the doctor sits on. but it certainly is not going to have as much value as it does to a doctor, which again allows us to, let's say, keep the medical practice with the doctor and transfer some other significant assets to the low-risk spouse. In some very extreme cases, doing something like just transferring assets between the two spouses in a common law state like New York or Florida, or doing a transmutation agreement in a community property state may not be enough. Sometimes you may need to do more, something that is a lot more difficult by the creditor to challenge, what we call a high-risk case or a high-profile case. And in that case, we may consider putting our clients through a divorce. A divorce gets the same result as a transmutation agreement or a simple transfer of assets, because in a divorce, assets get divided, and the judge gets to decide, or the spouses, if they agree on it, get to decide who is going to get what. So if the spouses get a divorce, and let's say again the wife is being sued for that car accident, they can take some valuable assets and get more of them over onto the husband's side of the balance sheet. Some divorce judge is going to stamp that separation agreement, and the spouses sort of go their separate ways. So the end result is exactly the same. Husband now has his own assets, and they do not belong to the wife. So why is it better than simply transferring assets or doing a transmutation agreement? It is a lot more effective, a divorce, because it's a lot more difficult to challenge by the creditor as a fraudulent transfer. It's very difficult for the creditor to go into court and say, Your Honor, these guys got a divorce not because they hate each other's guts, but because of me. It's a difficult argument to sell. It's not impossible. There are a couple of cases out there that have held a divorce to be a fraudulent transfer, but it's a very, very, very difficult argument to make. And the few cases that we have that held the divorce to be a fraudulent transfer, they kind of give us a roadmap as to how we need to do it correctly. And to do it correctly, the spouses have to do an equal split of the assets by value when they're doing the divorce, and they cannot continue living together. For some reason, the court did not buy the fact that this was a real divorce because the spouses continued living together. I didn't really buy this argument, because it should really be none of the court's business if they continue living together or not. Maybe they're trying to make things work and trying to reconcile. But we certainly should do an equal split of the assets by value. But again, we can pick and choose who is going to get which asset. Moving on. Okay, we'll talk about the use of entities in asset protection planning, what's called legal entities, I guess, as opposed to illegal entities. I'm not going to go through slide number 5 really. This is kind of the very basics of the choice of entity, the different types of entities that exist that we can use, LLCs, corporations, limited partnerships. We're going to go straight to slide number 6 and get into the heart of it. This slide is called choice of entity because here we're trying to pick what is the right entity for us to use from an asset protection planning standpoint. When our clients pick the right entity for their business or the right entity to own their assets, there are a number of factors that play into that equation. If you talk, for example, to an accountant, the accountant will tell you the difference between a C corporation and an S corporation, and is it better for a client, let's say, to have an S corporation versus an entity taxed as a partnership. So the accountant will go through an income tax analysis of how these different entity types play into the income tax analysis. Income tax planning and the tax consequences of different entity choices are important, but that's not the subject that we are covering today. Another thing that, let's say a corporate attorney or real estate attorney may discuss with the client are things like, well, just how flexible are the different entity types. From a purely business standpoint, what is the best entity for us to use? For example, corporations are subject to a lot of formalities. There are a lot of restrictions on how a corporation has to be structured, what the relationship among shareholders should be, voting rights, distribution rights, access to information, so on and so forth. Entities like LLCs and limited partnerships have fewer formalities. And there is